Good afternoon, everyone. My name is Michaela Moloney and I'm a partner in the Labour Employment and Workplace Safety team at K&L Gates. I hope everyone can hear me. Welcome to the April edition of HR Perspective, our monthly HR networking forum. We launched this forum in February this year, and it's designed to provide relevant, forward-thinking and timely information to you about law and various HR topics that will assist you in your HR practice. Obviously, when we met remotely for the first time last month, feels like a long time, much longer time ago, we were talking about changes to modern awards. That now seems very humdrum, and we could not have predicted what the next month would bring. Can I acknowledge and commend all of you for surviving the last 30 days and the twists and turns that it's brought the whole of Australia. In my experience, in the last 30 days, it's the HR personnel of organisations who've been at the front line having to field questions from management about legislation and rules that didn't exist 2 weeks ago. And I'm also aware that we have a number of in-house lawyers on the line who've been trying to do similar things. I'm also conscious today that we've got some business owners joining us, particularly from the retail sector. And I'm aware that for many of our clients, there've been a lot of heartbreaking and emotional decisions about shutdowns, standing down of staff, all because of COVID-19. So I'd like to thank everyone for joining us. Just in terms of some housekeeping issues, notwithstanding that we are a networking forum, we have muted everyone's microphone just to cut out the background noise. We've received a number of questions ahead of time. There is a question format, and I will try and keep my eye on things, as will John, as we go through. To the extent that we miss things, we'll try and cover off at the end. So if you have questions as we move throughout the presentation, use your chat button and we will attempt to answer those. Today we want to cover off on 3 large topics. Could I have the next slide, please? The first is the JobKeeper legislation and rules and the JobKeeper payment, which was announced as a concept about 3 weeks ago. The second is the amendments to the Fair Worker Act, the Fair Work Act, that really support the JobKeeper system, and that's what we've had a lot of questions about today. We also want to deal with, we're conscious that there are people who may not be impacted by JobKeeper, so we will talk to that as well, and then look at what it all means for you. So hopefully you'll find this informative. And I'll now pass over John to talk about the JobKeeper payment.
Thanks, Michaela. So the next slide, this just sets out that it's a package that's come through that in 3 pieces of legislation, 2 acts and 1 set of rules. There was the Economic Response to Coronavirus Payments and Benefits Act, which sets out the actual provision of the JobKeeper payment. That was accompanied a few days later by the rules which set out the real detail of the system, who is eligible, who is not eligible, how it will work. And then there was the Economic Response to Coronavirus Omnibus Measures No. 2 Act, which, as it says, is an omnibus act which set out some amendments to the Fair Work Act. And Michaela will talk to those amendments in detail a little later. If I could have the next couple of slides, please. The JobKeeper payment, which I'd like to talk to you about today, as I'm sure you'd all know, is $1,500 Australian dollars per fortnight from the 30th of March 2020. It's going to be available for approximately 6 months. Or 13 fortnights, and it will be paid in arrears each month by the ATO from the first week of May 2020. Could I please have the next slide? There's a few issues to take into account in determining whether or not you're able to access this payment. The first is whether or not you're an eligible employer. So there are several different turnover tests for eligible employers under this legislation and these rules. There's a question as to whether or not you are an employer who has a turnover of $1 billion Australian. That question is determined based on the group that you're a part of. It includes parent entities. Then the second test is how much your turnover has reduced, and this differs whether or not you're over $1 billion or not. If you're over $1 billion, then your individual company needs to have had a reduction in 50% of turnover. For those under $1 billion, then their turnover needs to have reduced by 30%. For certain ACNC registered charities, the turnover test is lower again, it's 15%, but there are particular exceptions to this, and universities in particular have a different scheme with some very particular things to consider, which if you are a university, we can certainly speak to you separately. Then there are exclusions to whether or not you're an eligible employer. So the types of employers who won't be eligible are those who are subject to the major bank levy, Australian government agencies, local governing authorities and wholly owned entities of government agencies, sovereign entities. So the government and the Commonwealth has indicated that for local governing authorities, the states should be responsible for any sort of subsidy that might or might not be paid to those entities. Other exclusions are those who are companies that are in liquidation, bankrupt partnerships, trusts or sole traders, and those who may be provided with separate support from the government, which might then require them to forego access to this payment in the system. If I could see the next slide, we've just set out the basics around calculating turnover. And again, it's very much in line with what I was talking about earlier. The tests include that all consideration from taxable supplies and GST-free supplies that are connected with the indirect tax zone. Obviously, Michaela and I are not tax lawyers ourselves, but have had to wrap our heads around these concepts quite quickly. We're very happy to talk through if you have any specific queries about whether or not your business might be eligible. We're able to talk in this forum to the general rules around eligibility as a business. But if you have specific queries, we do recommend seeking that specific advice. As I've said, the turnover test is applied to each entity separately when determining whether or not turnover has decreased by a certain amount. Intra-group supplies will be generally ignored, but such supplies should be taken into account for the purposes of JobKeeper, and gifts paid or provided to charities may be treated as consideration for a supply and therefore can be taken into account in calculating turnover. But as I said, if you have specific queries about whether or not the business itself is eligible, we're more than happy to discuss those on an individual basis. If I could see the next slide, and here we're talking about whether or not, what an eligible employer must do. Eligible employers need to make sure that their employees who are eligible receive at least $1,500 per fortnight. You as an employer need to obtain written notice from each eligible employee so that that employee confirms their eligibility. When you have nominated the employee to the ATO as an eligible employee, you need to then confirm back to the employee that you've done so. And you need to provide the relevant information that the ATO requires on a monthly basis. So that includes the issues that were set out there, the monthly turnover and the number of eligible employees. If I can see the next slide, talking about eligible employees. And here's where we have received a lot of queries. the first thing that needs to be taken into account is whether or not the employee was employed as at 1 March 2020. If the employee was not an eligible employee as at 1 March 2020, they will not be eligible for JobKeeper. This has resulted in some results that people might consider unfair. We've had queries from some clients, and the ATO sets out an example where an employee was a casual employee for a few months before 1 March. They get employed as a permanent employee as at 9 March 2020. And in those circumstances, the ATO says that they unfortunately will not be eligible for JobKeeper. The employee needs to be currently employed during the JobKeeper fortnight that they are applying for that the employer is applying for the JobKeeper subsidy for them. So what that means is that they need to have been employed as at 1 March, and they need to currently be employed when you apply for the JobKeeper payment. Sorry, when they receive the JobKeeper payment. Now, what this means is that you are actually able to rehire staff. There is no requirement that they have been continuously employed between 1 March 2020 and present time. In fact, the explanatory statement to these rules is clear that you are able to rehire an employee, and that is consistent with the purposes of this legislation, which of course is to ensure employees in Australia maintain their employment and their connection to their employer. There's an age limit of at least 16 years of age on the 1st of March 2020. They need to be an Australian citizen, an Australian permanent resident, or in particular categories of visa, which at the moment include the subclass 444 visa holder for a New Zealand citizen. As an eligible employee, you can only receive a JobKeeper payment from one employer. So the effect of this is that if an employee has multiple employers, they need to nominate one. And if they are a long-term casual employee, and we'll get to the question of long-term casuals shortly, but casual employees who have a permanent role elsewhere have to nominate their permanent employer. They can't nominate as a casual employee. As it says there, you need to be full-time, part-time, or a long-term casual, and there are some restrictions during the particular JobKeeper fortnight for which you're applying. You can't have been receiving the government's paid parental leave, and you can't have been totally incapacitated and receiving workers' compensation for total incapacity from work. I'll stop there for a moment and just go through a couple of queries we've had about those last few issues. The first one is, and we won't name employer names or anything here, but an employer had said that they were worried that some of their employees might make questionable workers' compensation claims to increase their payment on work while receiving JobKeeper, because obviously it is possible under JobKeeper to have your hours reduced as an employee and to receive less than your ordinary full-time pay. In terms of this, there's no exception for workers' compensation if the employee's got some capacity for work. It's only if there's a total incapacity that the employee will not receive JobKeeper. So it is possible that an employee may be receiving workers' compensation and JobKeeper. JobKeeper may be taken into account possibly in the calculation of workers' compensation earnings, but it is not a situation where workers' compensation is a blanket exclusion. It's only if the employee is totally incapacitated for work. And in respect of paid parental leave, the exclusion only applies in respect of the government's paid parental leave scheme. So what that means is if you as an employer are paying parental leave after the expiry of the government's paid parental leave scheme, then JobKeeper is payable as well, and you may be subsidised for that paid parental leave. The other issue is that during unpaid parental leave, JobKeeper is also payable. If we can move on to the next slide, and I'll just talk about long-term casuals. This is probably the area that we've received the most queries since JobKeeper was floated a few weeks ago and since it's come into effect. Long-term casuals are eligible for JobKeeper if they were employed by the employer as at 1 March for over 12 months, or 12 months or over, if they were regular and systematic and had a reasonable expectation of ongoing work. And what that means is it's a test that obviously has come through from unfair dismissal, and the concept of long-term and systematic casual employment there. It's a test that is quite difficult to apply on a general wholesale basis to all employees in your business, and ultimately certain judgment calls need to be made. It may be that certain ways that you can address this can look at the proportion of shifts that an employee has worked. You can look at a minimum number of shifts that an employee has worked. It's very clear that to be a long-term casual who's working on a regular and systematic basis doesn't mean that they need to work the same shifts every week. If they've got that reasonable expectation of ongoing work, then they could arguably just be working 1 shift a week, and it need not even be on the same day of the week. It can be quite difficult to narrow it down for those who fall into a grey area. And it does appear that there may be scope for the employer to nominate those employees about whom it's unsure to the ATO, and it is possible that the ATO may confirm of those employees. We certainly wouldn't. We would urge caution about paying such employees until you've had confirmation that they will in fact be eligible. If I can move on to the next slide, because I'm conscious of time, how much will employees receive when receiving JobKeeper? Sorry, if I could move on to the next slide. There we go. For employees who earn over $1,500 a fortnight, ordinarily or currently, then the JobKeeper payment is really a subsidy for the employer. The employer is not obliged to pay over and above what they are already paying the employee, but it is entirely optional for the employer to do so. And we're certainly aware of some employers who have decided to pass on some level of JobKeeper payment to, some level of that 1,500s payment over and above what they're already paying employees. If an employee earns exactly $1,500 per fortnight, then you just need to keep paying that amount. Again, it's at your option. You can certainly pay above that amount. And for those who are earning less than $1,500 per fortnight, the employer is required to pay them at least $1,500 per fortnight now in order to receive JobKeeper. So somebody who is earning $1,200 a fortnight ordinarily must now be paid $1,500 per fortnight. The way in which it operates is that the payments can include salary, wages, commissions, and bonuses, amounts withheld for tax or HECS, contributions made to superannuation that are those voluntary contributions under a salary sacrifice arrangement, but it does not appear to include your basic contributions under the superannuation guarantee, and any other amounts that have been withheld under a salary sacrifice arrangement. And now the last slide of this section. Back one. Yep. Other issues that do need to be considered in terms of the JobKeeper rules are that the payment of $1,500 needs to be made in the relevant fortnight. Employers may be able to, with monthly pay cycles, just make sure that they pay a monthly payment of $3,000, i.e. the tax office will take into account the pay cycles of an employer in determining whether or not the JobKeeper amount has been paid during the relevant fortnight. It's a reimbursement procedure. The employer has to make the payment first and then seek reimbursement from the ATO, and it needs to demonstrate that it did in fact make that payment to employees first. That said, and in the relevant fortnight, but that said, the ATO has indicated that for the first couple of JobKeeper fortnights, which are the ones that we're currently in, between 30th of March and 1 May, for those fortnights, it's indicated that it will accept some late payments because obviously the eligibility was not even, then the rules around eligibility were not even confirmed for some time. In terms of superannuation is payable on the amount of hours actually worked by an employee and what they earn for the hours worked. So that's the general rule. And if JobKeeper raises the employee's salary, that does not mean that super is payable on those additional payment amounts. That the effect of that is that if somebody is paid an extra $300 to bring their salary up to $1,500, you don't need to pay superannuation on that additional $300. If an employee is entirely stood down and not working at all, then super is not payable on that amount. And similarly, for any amount that you as an employer choose to top up an employee's ordinary wages because of the JobKeeper payment, again, there's no requirement for you to pay super on those amounts. So that is the super calculations there. In terms of tax, JobKeeper payments are passed through to eligible employees as salary and wages, and employers are required to withhold pay-as-you-go tax amounts prior to making payments to eligible employees, and the withheld amounts do count towards the $1,500 payment that you as an employer are required to make to employees each fortnight. We've highlighted at the end here some risks of claiming JobKeeper. Probably the key risk is as an employer may make a payment to an employee and then it becomes apparent that they are not eligible, and you may be required to repay that amount to the tax office with interest. There's a fundamental difficulty in the scheme here in that the payment is by reimbursement, and therefore you as an employer need to make the payment before you're able to claim it back. Other things to be aware of, though, are that there is anti-avoidance or anti-contrivance provisions in the JobKeeper Act, Payments and Benefits Act, which say that if you as an employer enter into an arrangement that is designed to create an apparent entitlement to JobKeeper when there isn't one, then that would be a breach of the JobKeeper Payments Act. And in those circumstances, penalties and criminal sanctions may apply. What I might do now is pass over to Michaela to talk about the amendments to the Fair Work Act and what the JobKeeper scheme allows employers to do if an employee is eligible.
Thank you very much, John. And it was remiss of me. I did mean to do a special shout out to Talia in our team who assisted with the slides, so thank you very much, Talia. We've just had a few questions come through, which I'll deal with briefly. One is whether if you're rehiring people, which JobKeeper does envisage, whether you should issue a new contract, and we would certainly recommend that you do. The other is in relation to the exclusion for paid parental leave, and that's the government paid parental leave that specifically excludes employees. What happens if an employee will be receiving paid parental leave for some but not all of the JobKeeper period? The rules envisage that, and I think that is fine, and the employee can become eligible even though they weren't for a certain period of it because they were receiving the paid parental leave. You'll just need to be very clear with the ATO the actual period within which you are claiming JobKeeper, because you can't claim it for the entire 6-month period if, for example, 4 months of it was the employee was on paid parental leave. So as John said, I'm going to talk about the amendments to the Fair Work Act for JobKeeper eligible employees. I just want to stress as we go through these provisions, one, these are kind of outside the box for employment lawyers and HR people because they enable you to unilaterally direct employees to do certain things. It is very important that everyone understands that if they relate only to employers who qualify for JobKeeper and relate only to employees who are eligible for that payment. So this is not a general amendment that applies to all employers. And in part 3 of our presentation, John will talk about what happens if you if you don't qualify for JobKeeper or you have some employees who are not eligible employees. But I just wanted to stress that from the outset. There's also been a little bit of confusion, and I confess myself being confused at times. There is a general stand down provision in the Fair Work Act, section 524, which a number of employers who experienced a stoppage of work in the early days used in order to stand down their staff without pay, and John will talk to that. Now there are provisions in the Fair Work Act that include stand down provisions relating just to JobKeeper. So I just want to specify that they are two different things, and hopefully by the end of the presentation that will be clear. So 2 weeks ago, a number of amendments were made to the Fair Work Act. They were obviously rushed through Parliament in a day, and those changes enable employers to make what are called JobKeeping enabling directions and also JobKeeper requests. And it's very important that we understand what can be directed and what can only be requested. So the JobKeeper enabling directions really fall into 3 key categories. And the first one is referred to as stand down, which is a little bit confusing because it gives the employer a right to direct an employee to reduce their hours or days of work, including reducing to nil, which is obviously what we generally think of as a stand down. So what that means, if you have employees who work 5 days, you can direct them to work 2 days per week. You may direct them to work less hours on particular days throughout the week, or you may direct them not to work at all. And they are known as the stand down directions, and specific rules, which I'll go through in a moment, relate to those stand down provisions. There are other directions that an employer who qualifies for JobKeeper can make in relation to eligible employees who are entitled to receive the JobKeeper payment. And they are to change the employee's usual duties and also to change the employee's work location. And one of the questions we've had, which we're having a lot, which is a little bit outside of JobKeeper, but I just want to address it because so many people are asking us, is about safety of employees while they're at home. I just want to stress that just because they are at home does not mean that it is not a workplace for the purposes of occupational health and safety and work health and safety legislation throughout Australia. It does not mean that you cannot receive a work cover claim. So employers do need to be very, very careful. We have recommended that if individual ergonomic assessments are not realistic, that you do give employees a checklist. That has led people to say, well, what does that mean if I get the checklist back and they say, you know, this isn't working for me, or my chair's unsuitable. I think as we enter into lockdown periods that are going to be significant, and when we know that the social distancing rules mean that some office workers will be at home for 3 months or 6 months, that is, I think, strengthening the obligations on employers to make sure employees are safe at home, including in their physical setup. Does it mean you need to go and buy them a $1,000 office chair? I don't think so. I can tell you that I came and got my own office chair because I sat in my dining room chair for one day and realised I wouldn't be able to work. So there are pragmatic ways around it, but I would say if you are aware of risks under using normal occupational health and safety principles, then you should be looking at reasonable steps to address that risk. So in terms of these JobKeeper enabling, I find it very hard, JobKeeper enabling directions, it is also very important to realise that these changes are temporary and they will only last until 28 September 2020, which is the period that the JobKeeper payment is in play. Now, that may well be extended, but we haven't got any notification of that. So what that means is you will, if you direct employees to stand down, they will have a right to return to work as at 29 September 2020. May I have the next slide, please? So I just wanted to go through, so whilst I've stressed that these are directions, that they can be made unilaterally, there are safeguards built into the legislation. Some of these have come about because of the ACTU's negotiations with government on the days leading up to the legislation. When you have a direction, it must be in writing. And you must notify and consult with the employees at least 3 days before the direction takes effect, unless the the employee genuinely agrees to a shorter period. And so there is a consultation process. Many of you will have that in your awards and your enterprise agreements anyway, but please keep that in mind. And you are also required to keep a written record of consultation. The direction doesn't apply if employees are taking paid or unpaid leave. For example, if they're absent on a public holiday or if you've agreed that they can take leave for a particular period. One question that we've had a lot of is how employees accrue leave for the period. And the legislation, and again, this is another safeguard for employee, makes it clear that employees will still accrue leave and their usual leave entitlements as though the direction had not been given. So they will be accruing it if they're full-time at a full-time rate, even though they may well have been directed to work part-time. Service throughout this period, even if you're stood, will be considered continuous for the purposes of redundancy. The other issue that's caused a little bit of confusion is, what do I pay the employee? During this period, obviously, John's gone through that when you are an eligible employer and you are receiving the JobKeeper payment, that $1,500 needs to be passed on to employees. What is really important to understand is if you are directing someone to work, and that's $1,500 per fortnight, if you're directing someone to work 4 days per fortnight rather than their usual 10 days, and they would ordinarily earn $2,000, then they are entitled to their ordinary pay during that period. You can't just say, well, you just get JobKeeper and that's it. So please keep that in mind when you're considering your requests and how many. And so we have a number of employers who are just saying, well, I'm getting this JobKeeper payment, otherwise I couldn't afford, so I'm going to talk to my employees and consult with them to work, 1 day a week, and the JobKeeper payment will cover it. If you issue a stand down direction, and that can either be reduced hours or nil hours, employees can come to you and request that they take on secondary employment. And we've had a number of employers who have been forced to stand down their employees, and their employees are now working in call centres, in supermarkets, and as teachers, those that are trained. If an employee comes to you with that kind of request, you cannot unreasonably refuse that. And obviously, the social policy behind that is that if people can keep working and earning money in this kind of environment, that the government wants them to. So please keep that in mind if you have people, and what's unreasonable, we really don't know yet in this brave new world. But I would think if it's something that completely conflicted with the days of the week that you wanted them to do or the duties that they're currently performing, then that may not be an unreasonable refusal. Next slide, please. So this is not a chance just to stand down employees that you don't like. These enabling directions have some other rules around them. And employers can only give employees a JobKeeper enabling stand down if the employee is unable to be usefully employed for their normal days and hours because of changes to business due to COVID. And unfortunately for many of you, you are very easily able to meet this test, but it is not a situation where, you know, if your business is still running, you know, as per normal, that you can just say to someone, well, actually, I just want you to, but you still qualify for the deduction. You do need to be able to show that they're unable to be usefully employed for their normal days or hours, or that they're unable to be usefully employed because of the government initiatives. So please also keep that in mind. There is an overriding obligation that the direction is not unreasonable, taking into account all of the circumstances. And again, this is a later amendment that was added due to some prompting by the unions. And the direction must be implemented safely. So there's an express provision that talks about that, including having regard to the nature and spread of COVID-19. So if you are in public-facing roles, making sure that if you're directing your employees to work at a different location, that they can do so safely. Next slide, please. The next enabling direction I wanted to talk about was changing duties. And so again, this is something that after consultation you can do unilaterally, and that is you can direct an eligible employee to perform any duties that are within their skill and competency but are different to their normal duties. Again, some riders around that. The duties must be safe, including having regard to COVID-19. Obviously, if there are required licenses or qualifications, the employee has to have that. So you can't just say jump on that forklift if that person doesn't have a forklift license. And the duties must be reasonably within the scope of the employer's business operations. So that's not within the scope of the employee's normal duties, but within the scope of the employer's business operations. And one of the examples that I've seen is a winery with a restaurant, where you might have people like chef and wait staff, permanent staff who are unable at the moment to work, and directing those employees to, for example, help within the picking grapes, for example. So that would generally be allowable under the changes introduced into the Fair Work Act. Next slide, please. Sorry, that should say changing location rather than changing directions. So you can give an employee a direction to change location, and that can include being at the employee's home. Some of the prerequisite is that the location should be suitable for the employee's duties. The employee is not required to travel unreasonable distances, so you can't say, well, now I need you to work every day in Warrnambool if that person's based in Melbourne, for example. It needs to be safe for the employee to perform those duties. The duties, again, must be reasonably, at the new location, must be within the scope of the business operations in order for those to be reasonable directions. Next slide, please. So if you are considering performing alternative duties or working at a different location, in addition to what we've talked about in terms of the consultation, the notice, the written direction, a direction will only be lawful and effective if it's necessary to continue the employment of one or more employees. And as I say, it's reasonable and that you've consulted with the employee. So that necessary to continue the employment is an additional requirement that's added in just in relation to when you're asking or directing employers to perform alternative duties or work at a different location. One of the questions that we've had prior to today's session is, can we start using JobKeeper enabling directions without formal confirmation from the ATO that we're eligible? I would recommend that if you want to make changes to an employee's employment, for example, reduce their days from 5 to 3, and you are not yet sure that you are eligible, I would make sure that you're ticking all the boxes in terms of the legislation. But what you might want to do is try and reach a consent position with the employee. I would be cautious about using directions if you're not yet clear that you are an eligible employee and that the employer and that the employee will be receiving a JobKeeper payment. Thank you. Next slide. So one of the things that was mooted prior to the legislation coming out was that there was going to be a new ability for employers to direct employees to take paid annual leave. That has not occurred as a result of these new Fair Work provisions, but employees may agree to take paid annual leave, and they may agree to vary their days or hours of work without reducing their hours, which is part of the JobKeeper enabling direction. Again, these changes will take effect from, so you need to give 3 days notice, you need to consult, and you need to give a written notice, but they will only be in effect for the period of the JobKeeper payment, and that is until 28 September 2020. Could I please have the next slide? So in terms of varying days of work, some of the requirements are, again, that the duties are safe, that the performance of duties is reasonably within the scope of the business operations, and that it's not reducing the employee's number of hours, because if that's the case, then that would occur via a direction rather than via a request under the new legislation. In terms of requesting that employees consider taking annual leave, one of the prerequisites to that is that complying with the request will not result in the employee having fewer than two weeks leave balance, and the request may also include that the employee agrees to take annual leave at half pay. So just to stress again, all of these are requests rather than directions, and part of the requirement is the employee must consider the request, and the employee must not unreasonably refuse the request. And we've had a few questions about what would be an unreasonable refusal, and I think it's going to very much depend on each case, and obviously the employer might be asking because they're in very dire circumstances. For example, if the employee said, well, I've got a wedding next March that I've been saving up my leave for, but I'll agree to a certain amount but not to the full amount, then that may well be a reasonable refusal. And no doubt over the coming weeks we'll see some more of those as they come through. But at the moment, there is no ability under the Fair Work Act, and there is under some awards, but there's no ability under the Fair Work Act to direct an employee to take annual leave if they're refusing to do so. Okay, I'm going to hand over to John just to talk through what does it mean if you're not eligible for JobKeeper.
Thanks, Michaela. And if I could go on to the next slide. We've put together some of the options that are available and were available before all of this occurred, and which continue to be available to people who aren't eligible for JobKeeper. One interesting consideration that's come through in some of the queries that have been made is whether or not people are able to pursue these measures even if they are eligible for JobKeeper, and they are. So here's something where even if you are eligible for JobKeeper in respect of some of your employees, you may decide that the better way to do things is to go through the existing provisions of law, the ones that existed before JobKeeper. And there are reasons that you might want to do so, some of which relate to the fact that things such as JobKeeper enabling stand downs, directions, will come to an end at 27 September 2020, whereas these other measures can be adopted in a way that takes them past that date. So I'll just run through these, and some of them will be quite familiar to you all. Obviously, working from home or another location. Now, JobKeeper allows for a direction to that effect in accordance with the JobKeeper requirements. It is, however, possible that employers are already able to direct employees to work from home. It really depends on whether or not it is a lawful and reasonable direction for the employer to make the employee work from home, if it's within the reasonable scope of the contract, and arguably for office workers it might be, whereas those who can't easily work from home or have jobs that are not of the type that would easily be working from home, it may not be within the scope of the contract to do so. As Michaela said earlier today, really, we've been saying that employers should consider requiring staff to complete a home office self-assessment safety checklist. And then we do note that new requirements are being introduced into certain modern awards, or have been introduced into certain modern awards, which might make it easier to direct employees to work from home or another location. Similarly, redeployment and other duties. Again, something that you're able to agree or direct employees to do under JobKeeper, and also varying days and times of work. It might be something that you're able to unilaterally direct as well. Again, if it is a lawful and reasonable direction, you need to consider whether it falls within the scope of the existing contract, whether it falls within, for example, if the employee's hours of work are expressly set out in their contract, it's unlikely that this will be an easy option for you. But again, it is also something that you're, in all scenarios, able to seek agreement with your employees to do so. In terms of other things that you may be able to do, you may be able to direct employees to take leave. However, most of the time this requires agreement. For award-covered employees, usually you can only direct employees to take leave if they have excessive leave, which means leave of over 8 weeks, and they need to have had that for about 6 months, and there needs to have been an attempt to agree to when leave would need to be taken. That said, certain awards, including the Clerk's Award, have now introduced the capacity to direct a shutdown, and I'll discuss that a little later, but that is something that may allow for directions to take leave for award-covered employees. For those who are award-free, the Act does allow for you to require employees to take leave if it is reasonable to do so. And in that scenario, I think it really does, the question will be, what is reasonable in the present circumstances? Here, especially if somebody is eligible for JobKeeper, it might be considered unreasonable to direct them to take that leave when there is the requirements or the ability to make a JobKeeper request in which the employee can't unreasonably refuse. So reasonability really varies depending on the circumstances. And there are special notice requirements which apply when you're directing employees to take long service leave. So again, directing employees to take long service leave is something that's available. However, depending on which state you're in, it can vary from about 1 month to 3 months notice being required. Reducing employees' hours and pay, and this is something that we've advised a lot of our clients around doing. Ultimately, this is something that if you're not eligible for JobKeeper, needs to be by agreement. The hours of work that employees have and pay are pretty fundamental elements of their contract, and therefore, in order to vary the contract, it really needs to be done in writing, through a letter of variation, perhaps through a letter in which the employer sets out a previously agreed variation, and states that the employee, by continuing to work, is deemed to accept that variation. That's also a possibility, although it is, of course, more uncertain than a signed written variation. And some awards have recently been varied to allow for majority agreement to reduce the hours and pay of employees. So that's something that if you are in one of those limited awards that allows for that reduction, you may be able to reach a majority agreement with your employees to reduce the hours, and that way you don't require individual agreement with each employee. The next slide, please. Sorry, if I could get the next slide. It talks about, yeah, there we go. Leave without pay is also an option, but it's one that really, again, requires the agreement of the employee. Say for stand down, which might be considered sort of leave without pay. There's really no capacity to direct employees to take leave without pay, unless there's something particular in any enterprise agreement or award, which may be very specific to the circumstances. If you enter into such an agreement, it really should be in writing, again, just documenting that the employee has agreed to not be paid for a particular period. Voluntary redundancies are something that hopefully you don't need to implement, but may be an option for employers. Shutdown is what I was referring to earlier, where some awards allow for the shutdown of the business in certain circumstances. That's usually what's relied upon for our Christmas close downs, Christmas and New Year. Really, any shutdown needs to be in accordance with the terms of the relevant award. Some of them allow for just the direction to take paid leave. Some allow for the direction to take paid and unpaid leave if an employee doesn't have sufficient leave accrued, but those are relatively rare provisions. And again, it is possible for award and agreement-free employees to direct those employees to take leave if it is reasonable to do so. As it says on the slide, you must provide notice of shutdown, and in a lot of awards that's 4 weeks notice, although again, recent changes to modern awards, including the Clerks Award, allow for that to just be 1 week's notice. And then if I can look at the next slide, that talks about stand down, which was about 2-3 weeks ago, the hot topic that everybody was looking to deal with COVID-19. And in some ways that has been superseded for those who are eligible for JobKeeper with the JobKeeper enabling directions. I'd like to spend a little bit of time on stand down because it is something that you may still wish to rely upon, particularly if you foresee that your business may not immediately bounce back after the 27th of September 2020. In order to be able to rely upon stand down under the ordinary provisions of the Fair Work Act, so section 524, there are 4 conditions that you need to satisfy, being that there's been a stoppage of work So it couldn't just be a shortage or reduction of work, but there has to have actually been a stoppage of work. And that could be, for example, that the work was unlawful due to restrictions brought in by COVID in response to COVID-19, or that in order to realistically comply with those restrictions, the business could not safely do so and therefore had to shut. It doesn't just refer to a reduction in the amount of work or a downturn in business. There needs to be something more than that, though. The employer cannot be reasonably held responsible for the stoppage of work. The employee cannot usefully be employed, and that has to be because of the stoppage of work. We've seen, in light of JobKeeper, a number of employers wanting to bring employees back from stand down and employ them on reduced hours. And that's certainly something that's the JobKeeper enabling directions. However, we do urge caution for a number of reasons in that regard. The first is whether or not anything has changed, which means that now there is useful work for the employee to do when there wasn't before. Because if nothing has changed and there's no reason why things are different now than they were before JobKeeper in terms of work for which people could usefully be employed, then there's a risk that the previous stand down was not valid. The other issue to just be cautious of is one about going forward, and shortly, Michaela, you about what we do going forward. But if you bring people back on JobKeeper enabling stand down because you're in receipt of JobKeeper, there may be problems when JobKeeper enabling directions come to an end if your business is unable to sustain the full-time employment. If you want to then go back to relying on stand down, it may be difficult to do so if there's been work which they've been performing for some time now. So those are just a few things that would indicate caution about the interaction between stand down and JobKeeper enabling directions. It's not to say that it shouldn't be done, but we do encourage you to consider what the implications will be about doing so. And then finally, the last option, which we've just indicated, because it is always an option in these circumstances where there's been a downturn in business, is that the employee might need to be made involuntarily redundant. But again, we do encourage businesses to turn their minds to the future, to what their business will look like after COVID-19 pandemic has passed or abated, and whether or not they'll require that work to be done in the near future. And I'll pass over to Michaela again to discuss what that near future looks like.
Thanks very much, John. I'm just going to check, yes, I am off mute. These are some questions. I don't propose to have any of the answers. I think what we can say is this is not going to be something where on the 28th of September, suddenly all of our businesses are back to normal. It is a bit of crystal ball gazing, but there will obviously continue to be social distancing. So for a number of our clients, there's going to be, continued effects on an ongoing basis, and that's particularly people in industries like retail and sports and theatre and live music. For many of our clients, there's been a delayed impact. So it might be that, they're 3 months behind their cycle, or they're relying on funding that's currently coming through but may not come through in the future. And in some ways, I think those employers are going to be really hard hit because they may not have the benefit of JobKeeper going forward. I think that as businesses and as people who look after employees, we need to start thinking about the long-term effect on our teams and what steps we can take. So obviously at the moment that's staying in touch. If we have people who are going to work from home for for 6 months. I mentioned the safety aspects, but also how are we going to develop our teams, because that's a very large part of what we do for our employees. So how do we look at that? Ultimately, our advice is to start thinking about this when you get a chance, because it's been a very busy few weeks. And we imagine at this stage that we'll be dedicating the next few HR perspectives to considering these issues and using it as a forum to share ideas among the group about what business as usual will look like towards the end of the year. And our discussions obviously always focus on your most important resource, which is your staff. So that's just a nice segue to talk briefly about what we're going to do next month. We have Dr. Melissa Lehman, who's a clinical and organisational psychologist from N-Action Psychology, and she's going to speak to us about some of the mental health issues that she's seeing coming out of the current circumstances. For those of you who are based in Melbourne, you might recall that Melissa presented at our February HR perspective on vicarious trauma. And you'll know that she has a really great way of just breaking down mental health issues and making it very relatable and digestible for people. So we're very grateful that she's agreed to come back. She's very busy at the moment, as you can imagine. And there's a lot of information circulating out there. There's a lot of really high-level commentary, but we thought it would be useful to have an expert to come and share some of her experiences and her hands-on experience dealing with her clients, which include both private clients that she has who are suffering from stress and anxiety, and also employer clients. As was the case today, we're expecting a large number of people. So if you do have questions, and you want to send them through to John and I beforehand, we're very happy to provide those to Melissa and try and deal with them throughout the session. I think we've hopefully answered a lot of the questions that you've had. I'm conscious that there's a few others about the interaction between, we stood down before and now we're using JobKeeper enabling directions. And as John said, whilst it's easier in a sense to use the Fair Work Act, if you think there's going to be long-term effects on your business, then you may want to do it by consent if that's a possibility for you. People have asked, well, should we be amending our contracts? If you're doing it as under the Fair Work Act, that's not strictly required, but if you're doing it by consent, it does amount to a variation, and there's various ways you can do that. The traditional way is obviously to have an employee sign a new contract or sign a variation. We're seeing at the moment with people scattered everywhere that employers are using different kind of techniques to say, well, if we don't hear from you, then we'll assume that you did consent. And so that's a sign of the pragmatism of the times. People have asked if we can pay reduced hours and the JobKeeper. There's absolutely no issue with paying more than the JobKeeper. The issue is that you must pay at least $1,500 to all employees who qualify for it. So we might leave it there because I'm conscious that we are over time. Thank you everyone for your attendance, and I know what's a very difficult time for most of you. If you have feedback, please let us know, as we want to make HR Perspective the best HR forum that we can. And we hopefully look forward to a lot of you joining us next month to hear from Dr. Melissa Lehman. Thank you very much.